Hello and good morning, everyone. Welcome to the latest in our Pulse Advisor webinar series. My name's Paul Foreman, International Sales and Technical Manager here at Novia Global. And this morning's session is called, Are You Sure I Need a Will? Delighted to be joined by Paul Flude. Paul's from Flude Associates, and they are a member of the QB Partners Expert Panel. QB Partners being our technical connection. Paul's a South African based in London. He's an attorney with over 25 years experience, and he specialises in dealing with internationally mobile clients across multiple jurisdictions. So a real expert for us to have today based on the clients that you guys will be dealing with all around the world. The session will last 30-35 minutes this morning. There will be an opportunity for questions and answers at the end. And of course, as usual, if you do have any questions, you can use the Q&A tab at the bottom of your screens. So with that, I'll now hand you over to Paul. Thank you.
Thank you very much, Paul, for that kind introduction. Good morning, everybody. And thank you very much for inviting me to this very topical session on wills. Wills are absolutely topical and relevant at the moment, and in particular, over the last 2 years. People are definitely talking about wills more, and they're talking about their own mortality, perhaps. And sadly, many people have suffered bereavement in the family. So, as I said, this topic is extremely important, and I will be covering the importance of having a will, what to discuss with clients to include in their will, and then specifically for advisors, how wills could potentially unlock assets under management and deepen your client relationships. I'm also going to be looking at why having one will per jurisdiction is important, and why just having one universal worldwide will is not a good idea. And during the course of the discussion, I will be mentioning some common mistakes in wills, but more positively, I'll be pointing out that things that one should put in a will and what is important. If we do have time at the end, I will go into a little bit more detail as to some common mistakes that I've come across in practice over the years, and more recently, particularly with internationally mobile clients. Now, the great Harry Barker, who is a very well-known legal scholar in South Africa, he said that failing to make a will is selfish. It leaves your family with a financial and personal mess to clear up. It could severely prejudice your business or property interests, and even worse, it could have a detrimental effect on your minor children. And I think that this quote sums up the importance of having a will so well. It is definitely the most important document you will ever write, and affects every single aspect of your life. Next. I've often joked, where there's a will, there's a relative, rather than where there's a will, there's a way. Because often what we will find is if you don't have a will, some relative will come out of the woodwork, so to speak, or if there's a badly drafted will, there may be a relative who lays claim against your estate. Remember that all other legal documents can be revised, cancelled, amended, and interpreted by the author. But on death, a will is final. Not having a will, or having a badly drafted will definitely lead to disappointment, disaster, heartache, and tears. And of course, there will be an inordinate delay in the winding up of your estate. Now, often clients, and I get it all the time, clients come up with excuses for not doing a will, such as, I'm too busy, I'm not married, I don't have any children, no budget, I'm not rich enough, will's only for rich people. Everything is in trust, it's not necessary, the law decides, my family will divide everything, wills only cause trouble. And no, I don't want to think about that, it's a morbid chore. Well, let me say that on the face of it, these may appear to be valid, but they definitely are not. And it is your duty as an advisor to explain to the clients why these excuses are not actually valid. Just picking on two, everything is in trust. Well, there will almost certainly be clients who have much of their wealth in trusts or other structures, but one should still do a will. And I'll come to that later, why certain things need to be done in a will. Remember, certain assets come out of trust at times, or clients acquire assets out of trust. So it is important for those wealthy clients to have a will. The other one is, my family, I've told my wife, I've told my children, they'll divide everything. Well, sadly, often that isn't the case, and it is an extremely risky approach to estate planning. Remember, most families can't decide what TV show to watch or where to go on holiday. I would say if you've got one heir, one asset, and you have no minor children and you are unmarried, you should still have a will. Next. So what happens if you don't have a will, or a badly drafted will, or the will is declared invalid, or, as happens sometimes, the will is lost or destroyed? Well, then you have an intestate estate. Now, an intestacy or an intestate estate really causes huge stress and complications for the family. I can't stress that enough. It is a massive stress. It causes a financial mess for the family. More importantly, your freedom of testation, the wishes that you want to put down in the will as to how your assets will be divided and who will get what, will be overridden by the laws of intestate succession, which provide a fixed devolution of assets. More importantly, you may have the specter of having to trace beneficiaries, which often takes many years. All of the above will lead to delays, and as advisors, you know that delays could be a death knell to assets and their potential to grow. Most people are very busy and often don't have the additional budget to devote to fixing up an intestate estate, and that only exacerbates the problems. Next. Just to run through some of the things involved in an intestate estate and why, again, it is so important to have a will and an up-to-date will. I mentioned that there will be a fixed and arbitrary formula for the division of the estate. There is absolutely no scope for your personal wishes or different percentages. Distant blood relatives, and even in some cases the state, shock horror, may benefit from your estate. So cousin Melvin, who ran over the family dog last Christmas, may actually inherit some of your assets. Your spouse, civil partner, may not receive a full benefit. In certain laws, the estate is divided between the spouse and the children. On the flip side, if you wanted to benefit your children, say 50% and your spouse 50%, your children may not receive the full share that you wanted them, but more importantly, their assets may have to be held by some state institution because you don't have a will, and therefore a will trust won't be created. All in all, it leads often to family battles over the division of the assets, the properties, the businesses, the pension benefits, and all of that will cause a delay. No executor could be appointed for some time, and no guardian for your minor children. All of that causes delay and anguish. Remember, if an executor not known to the family is appointed, they are more likely to make decisions inflexibly and will not take into account anything that's been before or some of your personal wishes. Bank accounts and business assets could be frozen for long periods of time. And then, of course, from a cost and a cash flow point of view, there will always be increased administration costs, legal costs if there's a court battle, and other costs such as valuation costs, travel costs, tracing costs, all of which would not have been occasioned if you just had that piece of paper called a will. Next. So in summary, not having a will is a grave mistake. Forgive me for that one. Next. Having an up-to-date and a valid will give you peace of mind. It gives certainty and clarity as to the devolution of your estate. There won't be an intestacy, which means there will be fewer delays and fewer costs. And those are good things for advisors and for clients. It obviously prevents family disputes. It prevents third-party attacks, maybe an attack from a creditor or somebody else in the family or an unknown heir. And more importantly, having the will in place allows multi-generational and multi-jurisdictional planning. And of course, everything leads to the protection of those assets and the growth of the wealth for the client. Simply having a will, can't stress enough how important it is. Okay, next. The next two slides, I'll be looking at certain categories of people or situations which may apply to your clients. So have a look through them. And if any one of them apply, the client should definitely have a will. And this is possibly another way of handling some objections with the clients regarding the will. Definitely where people are unmarried and they own assets jointly, one should have a will. If you have minor children, if you want to nominate guardians who are perhaps non-resident in your country of residence. Most people these days have a particular family, financial, property, or tax situation. Remember what I said about the intestate succession laws? They are fixed and they are arbitrary. So it's very important where people have blended families, they have children from previous relationships, or perhaps there's stepchildren that you want to benefit in your will, or there's unadopted children. Those are very important reasons to have a will. If you're, as a married couple, have assets in excess of £650,000, and the reason I chose that number is it's because it's 2 times the inheritance tax threshold in the UK. Definitely if you have immovable property, and more importantly, if you're dealing with mobile clients who are moving from country to country, it's very important to have a will and to review their wills per jurisdiction. Next. If you want to leave specific cash or property or assets to specific people, or you want to make a charitable bequest, it's very important to have a will. If you own a business, have agricultural land, and you want to appoint a professional executor, more importantly, if you are about to get married or you've recently become divorced, those are important milestones effectively for reviewing and updating a will, but also making sure what the client's marital status is, because that will also impact on the succession laws. If your family calamity situation differs from the strict intestate succession laws, by that I mean is what happens if, heaven forbid, the plane goes down and the entire family is wiped out? Do you have a specific idea as to who gets what? Now, if that idea that you have differs from the succession laws, it's absolutely vital to get a will. If you've lived in multiple countries and you've possibly got a different tax residence, domicile, as we heard previously from Scott Hood, is a very important concept when dealing with wills. Residency, habitual residency are all concepts that have a very important impact on how wills are interpreted and the succession laws which are applicable to the various assets. And obviously, from a planning point of view, clients and yourselves will want to minimize estate duty, taxes, and legal and administration costs of the estate. Those are all extremely important reasons to have a will. Thank you. Next. A will is a personal document in all senses of the word. It moves with you on the path of your life. The will effectively it should match your personal financial circumstances. It's also never static, and we'll come to review of wills later on. The will must be tailor-made to fit your current individual and financial circumstances and wishes. I've said before that it is not just your will, but it is your will. And the emphasis there is it's your will. It represents your life, your personal assets, your personal family situation, but it is also your will in the sense that it is your intention that is recorded in the document. It's what you want. to do with your assets and with your family after your death. Thank you. Now we come now to a discussion about what to talk to clients about including in their will. Now, a lot of this is done obviously by the will writer or the lawyer in the various jurisdictions, but I think it's important for the advisor to get involved in this process because it will uncover certain information which will assist you in advising the client. Often the wills process starts with a detailed will questionnaire and also a domicile questionnaire. And in there, the client will include all their worldwide assets, their liabilities, if there's potentially claims against their estate in future, and if there's potential for inheritances. Now, each of those items is important to advisors. It may uncover other assets which you were not aware of. To discuss the pension, life, and beneficiary nominations. Are policies written into trust or not? Maybe there's an opportunity for you there if you uncover a policy which isn't written into trust, or maybe there is a cash shortfall or a liquidity problem with the estate. It's vitally important to get the full family details and the various relationships. Often clients refer to my children, but it could include stepchildren or unadopted children. Your marital status is extremely important because sometimes the marital status trumps the succession laws. There may be maintenance obligations or divorce agreements. That is a planning point to make sure that there's sufficient cash to take care of those obligations. If the client has specific bequests, maybe they want to bequeath some cash or some property or a car or even a family business. It's important to discuss those specific bequests in detail. There may be conditional bequests. Usually these are around timing. For example, I bequeath everything to my children, but they can't inherit anything and have the asset vest in them fully until the age of 25, 35 if they're my children. Also, it could be a bequest, a conditional bequest related to a business. So I bequeath the shares in the business to my son, subject to the strict condition that he has a business degree or equivalent at the time of my death, or has worked in the business with me for a period of 10 years. These are all conditional type bequests. Just remember, a bequest cannot be against public policy and has to be reasonably enforced. Importantly, when it comes to property bequests, I always say to clients, first understand what is the type of property that is being bequeathed. It may not be able to be bequeathed if, for example, it passes automatically to a spouse. Are there any conditions of title? And then what is it that you're bequeathing in regard to the property? Is it the property outright? Or is it just a right of occupation for an elderly parent or for a brother? Is it a right to rental income? And is there a time frame involved in inheriting the property? Are those assets possibly going to pass to another person on the death of the first person who's inherited the property? Those are all aspects one has to bear in mind when dealing with property bequests. Okay? One of the most important things in a will is to name residuary heirs. So after all the bequests have been paid, the tax and the costs, who is going to inherit the rest and residue of the estate? And the best advice here is make sure that they are clearly identifiable and that their portions are clearly identifiable. If you're going to divide your estate 40-40-20, as I've seen in wills, be careful. Make sure those percentages add up to 100. Seems like a silly point, but it often is overlooked and errors do creep in. I've spoken about the default or family calamity clause. So many standard type wills don't actually include this clause, and it is absolutely vital. And you'll find often with the clients that they have very specific views on this situation. And it's often not the mirroring of the intestate succession laws. Maybe they don't want everything to go to their parents. Maybe they want it to go to a brother who's struggling or a sister who's just started a business. Maybe they want to split the assets between their siblings. I also mentioned per stirpes or not. ask the question, what happens if in the event of your 3 siblings inheriting your estate, what happens if one of them dies? Is that share of the deceased sibling going to go to the other 2 in equal shares, or will it go to your niece and nephews? These are very important questions which should be asked and specified in the will. Importantly, you need to nominate executors and trustees, and this could be a spouse, family member, could be an advisor, a professional, a legal person. My view on this, generally speaking, and of course I'm biased, but a family member together with a legally trained specialist who's dealt with wills and estates is probably the best partnership for dealing with the deceased estate. You need to specify in the will also what the executor's powers and the trustee's powers are going to be. Are they going to be wide or are they going to be narrow? And here you need to strike a balance between ruling from the grave or possibly hamstringing the trustees with too few powers. Will trusts. What type of trust? I see so often people getting the trust wrong. They've either used a template will or they don't possibly understand that there are many, many different types of trusts. Who's going to get income? Who's going to get capital? How is that going to be paid? On what dates? When the trust is going to terminate? All of those things need to be specified and discussed. Business assets is actually a planning opportunity all on its own. And certainly for succession planning and discussion with businesses and business owners, the business succession planning is a very huge exercise. Who's going to take over the business, or is it just simply going to be sold? Are there going to be possibly key person policies in place to provide liquidity for the business? Those are very important points to discuss with the client. And then, of course, guardians, substitute guardians, and temporary carers. It's important to name a guardian for your minor children, but also many people nominate their elderly parent. I would say have a substitute guardian in case an elderly parent passes away before you. Temporary carers or temporary guardians are very important where the guardian that you've nominated in the will is not resident in your country of residence, and there could potentially be a delay, sometimes several weeks, between the guardian able to get visas and get on a plane and come and take care of your children. So in those cases, it's very important to nominate a temporary carer or a temporary guardian to look after the children in that time frame. A will should also deal with the softer issues like funeral wishes. And believe it or not, I've seen fights over funerals and ashes and how things were handled, which have actually spilled over into the fights over assets. They weren't going to fight over the assets, but then they had a fight over the funeral and the ashes, and suddenly they're fighting over everything. So please specify the type of service, the burial, who's going to conduct the service, whether the organ donation, where the ashes are going to be scattered, etc., etc. Thank you. Very importantly, we have things like digital and online assets. I think all of us have what we call a digital legacy to leave behind. Ascertain what those assets are. Do they pass automatically? Are there certain protocols online to access those assets, but also to pass them on? I know certain facilities or social media do allow you to have what's called a legacy person to look after that account after people die. Those are very important things which need to be actually looked at these days. Please look after the pets, care for the pets, make sure that the pets are, there's a mechanism for somebody to look after the pets. Perhaps there's even a financial requirement. Somebody looking after the pets is given 100 quid a month or whatever to look after the pets. You could also draw up a letter of wishes for sentimental items or to provide certain guidance for the family in regard to your funeral or perhaps other things such as how you would like your trust to be managed. Just remember, those letters of wishes are not binding. Other things that you need to look after when dealing with the clients and their wills are things like living wills and advanced decisions, lasting powers of attorney. I always ask the clients to leave a roadmap as well. And that really is quite a detailed document setting out their assets, setting out who their lawyer is, who their doctor is, if there are any potential, passwords and things. And there are various formats that roadmap can take and securities that go with it. Signature of wills and storage of wills are two big risk areas. So you can get everything right, get the will in place, and everything's tickety-boo. But unfortunately, if you sign the will incorrectly, or the will is lost or destroyed while it's being stored, those can create huge risk. So please make sure that you follow the strict formalities. Often with mobile clients, they've got 3 or 4 wills that they tend to sign in one jurisdiction. So that is a very important point. Make sure that they are signing that will so that it will meet the formalities in the jurisdiction in which it's going to be enacted. A codicil versus a new will. A codicil really is an addition to a will. And my general rule there is if there is a simple change to the will, you're increasing a bequest from 10,000 to 20,000, then sure, draw a codicil. But if there are multiple changes or major changes to the will, then I would definitely draft one new clear document and one new will. Remember, if there's multiple codicils, there's more potential for documents to be lost, but also they could create an ambiguity in interpretation. Thank you. Review of wills. This is a great planning point and an excuse for advisors to review the will with the client on an annual basis. Those items in orange, those are items which happen to all of us, most of us all the time. And my point there is wills quickly get out of date. Those items happen all the time, and each of them may have a detrimental impact on not only the validity of the will, but also the currency of a will. Okay, next. I often hear people saying, I have a simple will. It's a simple estate. But unfortunately, given the complexity of life and law and ever-changing complex legal, tax, and fiscal landscape, there is no such thing anymore, in my view, as a simple will. However, my point is, if you have the right advisors and you are able to gather the information with skill accurately, you should then be able to synthesize and organize that document and those wishes, no matter what the circumstances are surrounding that, into a simple document. Okay? For advisors, it's so important to understand that just dealing with the wills and the wills process can potentially unlock assets under management and deepen your client relationships. During the whole wills process, you are going to be privy to a whole range of personal, family, and financial information. You could be at meetings with the tax advisors. You could be doing cash flow forecasting or stress testing the estate plan. Often I've found people talking in anticipation of death tend to open up a lot more about their fears, about their family situation, maybe certain assets which you are not aware of. What are people looking for generally in life with their advisors? They're looking for people who care sincerely and people they can trust deeply. And the wills process definitely unlocks those opportunities for advisors. There will be opportunities to show your knowledge, to reveal your great network of people that you've got to assist the client. Obviously, they will edify you and you will edify them in return. And of course, that will assist the client relationships. Remember, what we are all looking for is the long-term relationships. And will planning, will review, and reviewing the will on an annual basis is all a way to build into those long-term relationships with generational estate, tax, and financial planning. One of the things I can tell you where financial advisors really deepen the relationship with the client, especially if there's been a death in the family, is they say they helped me in a crisis, particularly if you were calm, you were objective, and you didn't run when the first shot was fired. Remember, all the will process is very, very akin to the whole estate planning, and advisory process with the clients. It's relationship driven and it's solution driven. Next. Obviously, during the will process, you'll be talking to your clients about how to make savings in tax. And there are so many types of tax savings that one can look at across the jurisdictions. Of course, if you're able to put a tax saving into place, you will obviously deepen the relationship with the client. They'll think you're a genius, but also you'll unlock cash flow, which will increase potentially assets under management. Maybe they had earmarked a specific asset to pay tax. By saving that tax, that asset could perhaps be realized and invested in another way. During the estate administration, there's obviously opportunity for advisors to increase their relationship by having people around them who can deal with the estate with speed. And of course, when those funds are invested or come to vest in the heirs, you will have an opportunity to speak to those heirs about inheriting those assets. There's opportunities with will trusts and other trusts, obviously time to review their pension funds, their life cover, their business assets. All I'm saying is that this leads to what we call a virtuous cycle of reviewing, rationalizing, and actually growing the portfolio. And all of that actually starts and ends with the will process. It creates loyalty for you with the client, and in turn, you will be able to add value to the client as well. Many of the advisors I know who've got very long-standing clients, they say, not they look after my money, they say they look after me and my family. And remember, of course, the converse is also true. A bad estate plan, a bad financial plan, lack of knowledge, and an estate that goes badly and no will could also potentially end the client relationship. Next. Remember that a well-drawn will and an up-to-date will ensures that assets are not only protected, but they are distributed quickly to the heirs. And that is the goal, not just for you, but for the client as well. It ensures that the assets are protected, there's speed, no delays, you can make decisive action about the assets, assets under management are protected and increased, and all of this will give you a solid platform for generational planning. Okay, next. Finally, we're going to have to look at the very important topic of why having one will per jurisdiction is important. Most people have so-called universal will or worldwide will, and that is definitely not appropriate to cover all the complexity in one single document. Remember, each jurisdiction has its own laws, its own practices, its own probate authorities. There's common law, Sharia law, civil law, customary law. There are certain ways where a will in another jurisdiction could potentially have forced heirship, the concept where the spouse, children, and family members have to receive a benefit of the estate, no matter what the will says. There's different laws regarding immovable assets like properties and movable assets like cash, shares, and furniture. Now, how possibly can that all be encapsulated in one document when you have an internationally mobile client with assets in various jurisdictions? So it's vital that they have separate wills in each jurisdiction where they have significant assets, particularly if they have immovable assets. Remember that the terminology and legal jargon differs per jurisdiction. So a will drawn in South Africa or in the UK may be absolutely inappropriate in Portugal, Malta, or Spain. I often find people simply lump together the UK when actually the client has assets in Scotland or the Isle of Man or Jersey or Guernsey. Remember, each of those are separate jurisdictions with their own laws. And in many cases, having one will could create an ambiguity or have terms which are unenforceable in those jurisdictions. Next. Remember, there's also no concept of trust in many countries. So if your will refers to a trust, it may not be enforceable. Some countries don't allow power of appointment, and the will may fail if your will includes a power of appointment, and in that jurisdiction, they don't allow that. There may be, in fact, a partial intestacy. Very, very importantly, where you have jurisdiction-specific wills and other wills, they need to dovetail together. Most wills contain a general revocation clause. So where, for example, a client who is UK domiciled, UK resident, has assets in Portugal, South Africa, and the Isle of Man, it would be strongly advisable in that scenario to have a Portugal will that only applies in Portugal, a South African will that only applies in South Africa, and then possibly the master will drawn in England and Wales, which covers the rest of the world, but does not knock out the South African and the Portuguese wills. And so often that actually does happen. One should cover the world in wills. We often see a situation where a person draws a specific will to their jurisdiction, then they move to another jurisdiction and draw a will specific to that jurisdiction. But then they acquire assets in Bulgaria or the Isle of Man or in the UAE. They would potentially be intestate in those jurisdictions if they only have jurisdiction-specific wills. More importantly, a separate will in a separate jurisdiction, you will be able to appoint a local executor to deal with the assets simultaneously. You won't have to wait for the estate to be wound up in one jurisdiction and then moved on to another. In that way, assets are protected, but also assets can be ring-fenced per jurisdiction. Importantly, also from a planning point of view, you can make sure that cost centers are kept per jurisdiction. So, for example, if one estate has to pay estate duty, but one country doesn't have to, you can potentially ring-fence those costs in one jurisdiction. And that cannot be done with one universal will. Thank you. And finally, let me just say that one should regard the will process and the importance of a will and the drafting of a will as part of wealth planning and wealth protection. Drafting a will is not a standalone process. Another point I want to make is that clients often focus on the price in drafting a will and not on the value. You need to help the client understand the value of having the will, and hopefully I've got across some of the items this morning, but also the net effect of not having a will and the detrimental effect on their wealth if they don't have a will. In summary, drafting a will, having an up-to-date will not add value to your client relationships, but will add value to the clients. It will add value to yourself as an advisor and also deepen your client relationships. Next. I mentioned I was going to have some case studies if there's time, some various examples, but that pretty much brings me to the end of the presentation. I know we had a huge amount to cover, but thank you very much for your time and attention. And if there's any questions, myself and Scott Hood are here to answer. And back to you, Paul.
Thanks a lot for that, Paul. All very useful information and lots of good hints and tips in there, which I'm sure the advisors can use with their own client banks. As you say, we've got Paul here for some questions and his colleague Scott from QB Partners. One which has come through to us this morning, Paul, from Spain, is looking at a typical mirror will situation. And on the death of one of the spouses, if the surviving spouse has inherited the estate 100%,
yep,
does the original will still hold good, or should they draft up a new will now that they have inherited those assets going forwards?
There's two very important points to this question, and thank you very much for asking the question. The first thing I'd say to you is that when we went through the reasons to review a will, a death or a remarriage is a very important milestone to review an existing will. To answer the question, there will potentially, unless the trust has been created or some other mechanism, when the husband passes away and the wife inherits everything, they will effectively own 100% of the estate. Now, depending how they're married, and of course, if there's other conditions or mechanisms in the will, that spouse then is free to dispose of those assets as she wishes. So the first thing I would say is, having said that, it's a very important point. Obviously, one does want to wait a sensitive period of time if people are grieving before you discuss writing a new will. The second thing I'd say is that this is also an important point where it comes to what we call sideways inheritance. So, for example, if the will, the husband and wife having mirror wills, if they said, for example, that in the event of both of their deaths, that the assets pass in equal shares to the children, if the event is that the husband dies and the wife inherits everything, she is then free to change the will. And that could potentially end up meaning, if she remarries or decides to give everything to the cat's home, there could be a sideways inheritance and your children could get nothing. So from that point of view, mirror wills are extremely good and very, very useful and simple construction, but they do have their downfalls. And so it's very important to speak to this about the client. I would say in that example, those assets are vested. It's a very good opportunity for her to update the will. But of course, the original mirror will stand if she doesn't update. I hope that answers the question.
Great stuff. Thanks for that, Paul. I think another one's just popped into the inbox. Are there any countries that you would specialize in when writing wills for clients? So what would be your area of specialism, Paul, in particular?
So I would say, thank you. I mean, my obvious area of specialism is South African law, South African wills. I have drawn some wills in conjunction with clients in other African countries like Namibia, Zimbabwe, and Botswana. Obviously now being here in the UK for a number of years and working closely with solicitors and drafting wills and working with people like Scott, we can draft English law wills. I have lived for a time in the Isle of Man and worked for a period of time in Switzerland and in Guernsey. So there are, those countries, definitely I have certain experience in drafting wills. But lastly, I will say that the best will writers, the best estate planners, best private clients tend to have an arsenal of people around the world, because with mobile international clients, anything can come up. We might be asked to draw a will in Mauritius. We might be asked to draw a will in the United States or Australia or Canada. And usually what happens is we have a number of people that we can call on in order to coordinate everything. Usually I act as the sole point of contact for the client in coordinating everything. And importantly, there are a host of laws in, for example, European countries that a person like me possibly, it's impossible for me to keep up. And one does need to lean on the expertise of people in those jurisdictions whilst one drafts, say, the master will in South Africa or in the United Kingdom.
Great stuff. Thanks for that, Paul. In terms of, we've got a couple of minutes left. In terms of the common mistakes or pitfalls to look out for, is there anything you would flag today?
Yes, Paul. I mean, I've come across so many mistakes in wills or errors, possibly with the planning as well. And I've got a couple which I can run through, if we're just waiting for other questions. Recently, I had somebody who filled in those horrific template wills. It was an online will, and they filled in the box dealing with the executors, but under beneficiary, they left it blank because they thought that by naming their two children as executors, that also meant beneficiary. Now, that will, unfortunately, would have a major problem of interpretation. I mean, you and I would know that she would clearly want her two sons to inherit. But because she didn't fill in that block, there could be a potential problem there. One of the things I've also said to clients is the will moves with you through your life, especially when there are fiscal and tax changes. And often I see people using sort of standard precedents which have tax tricks in them, reserving certain amounts of assets which are tax-free into a trust. Now, those wills need to be reviewed constantly because those constructions may not be appropriate. In South Africa, there was a certain construction where we had 3.5 million rand bequeathed to a family trust. Now, that's no longer necessary because we now have what's called the portable estate, similar to the UK, where 7 million can actually pass on to the surviving spouse and the heirs tax-free. So those constructions might be a problem. Just lastly, I'd mention as well, if we're waiting for other questions, I recently had a case where a client presented wills to me, one in South Africa, one in the UK, perfectly put together, but wanted her South African properties to go to her son and her England properties in England go to her daughter. At the time that the wills were drafted, there was complete parity between the two bequests. But unfortunately, we know currencies, specifically the rand, is volatile. So what actually happened is I did a simple calculation and I worked out that there was a 30% discrepancy between her son and her daughter. So sometimes in a case like that, bequeathing specific properties to your children, thinking that it's going to be even, requires you to review that and make sure that that's actually what the client wants. Another famous one also is leaving £20,000 to all of my grandchildren alive at the time of my death. Remember, when you draft the will, if you've got 3 or 4 grandchildren, you may have 15 at the time you die, which means there may be a liquidity issue on death. That's a common mistake I see with people, and that's a planning point as well, to stress test the estate and to do the annual review. I'll stop there, but Paul, I've got some others I can mention as well, but just waiting for other questions.
Yeah, I think we're starting to see a couple of people drop off the line now. So I think if we look to wrap up, but obviously if anyone does have any specific questions or examples, we can refer on to you going forwards, Paul.
Absolutely.
What we'll do is, obviously, this is a sort of series of webinars that we've been doing with QB Partners, and we've looked at domicile. We're looking at wills today, and estate planning is the kind of theme that we're looking to run as a thread through all of these. So watch out for future webinars going forwards. Thanks to Paul for your input today, been really useful. And going forwards, we won't be having a webinar in December. I'm sure you've probably got more important things to do, whether that be Christmas shopping or getting those end of year clients on the books in time. So we will be having our next webinar early in the new year. So watch this space for the invite for that with one of our asset manager partners. So just leaves me to remind you that obviously we'll have a copy of the slides and the video from today available. So whether you want to have a quick refresh or share that with any of your colleagues. And as I said, if there are any queries on the back of this, we'll be able to refer you to Paul and the guys at QB Partners to look into that for you in more detail. So that just leaves me to say thank you once again for attending today, and look forward to catching up with you all in the very near future. Thank you.
Hi.